And hey guys, welcome back. Should be looking page 2 of the purchase agreement. Starting with paragraph 5, it's a contingency on the sale of the home. What I want you to be aware of here is it's a simple checkbox that the offer that you're making is contingent or is not contingent upon the sale or closing of the buyer's property or the closing of other assets. So the closing of a home is an obvious one. If they're making their offer subject to the closing of their current residence or any other residence, that's contingency. When we speak of other assets, that could be something as simple as pulling money from a 401k. The bottom line is really we're just doing a disclosure. And if so, there should be an addendum attached to that, and check with your broker manager regarding what the appropriate addendum would be for that. Now, number 6 is something that is still relatively unique to HRC Realty, Coldwell Banker Professionals, Century 21 Professionals, where we're putting the buyer broker compensation directly on the purchase agreement. So when we first met with the buyer, we spoke with them about the options on how they would compensate us. As you know, the buyer is responsible. They've signed a contract to make sure that we get paid. Now, how they get us paid, well, there's options. The option that we believe that we want to lead them to is to really be in the aspect of we're going to build it into the offer by asking the seller to pay that compensation. So here's what the paragraph says. First, there's the disclosure. It's not set by law. It's fully negotiable. And it states that the compensation will be paid by, 1, the seller. And here's the way it is written. Who shall contribute blank dollars or blank percent. Most of the time it is going to be the percentage. We know that as a company we want 3% of the purchase price, which is to be credited toward the buyer's broker's fee. And that would be us when we're completing this purchase agreement. Now, the other option is the buyer could pay this out of their own pocket. And there's nothing wrong with that. As a matter of fact, you may want to consider how to negotiate the offer if the buyer is paying cash for the home. Because at that point, they could pay us directly. There'd be no reason for them to have the seller pay the buyer broker fee. Talk with your managing broker in regards to that to help that make a little bit more sense. But if so, we would check this box and then who will pay either the dollar amount or our preference is the 3% of the purchase price. Now, this is rare, and know that when we receive these offers, we will not do this. We do not, as a listing broker, pay compensation. We are not going to be the one responsible. It is rare one of our buyers would have us check this, but it's an option. It just doesn't make sense to do, however. All right. It also states that these amounts will be credited toward the buyer's obligation to the buyer broker at the time of closing. Number 7, and this is important to know, is separate from buyer broker compensation. This is seller concessions, and as the paragraph says, let me read it, sellers hereby agrees to contribute blank dollars or blank percent of the purchase price towards buyer's prepaids, tax prorations, closing costs, or any other allowable expenses. Now, who's going to determine what allowable expenses are? Well, that's the mortgage company. They're given the money. Either the dollar amount or the percentage, and this is a conversation with the mortgage person. But know that the buyer broker compensation must be different These two being different, this is applying directly to the compensation. This is seller concessions. It is toward prepaids, taxes, prorations, closing costs, allowable expenses. They must be kept separate. And that is due to the way that the lending must be done based upon government regulations. Paragraph number 8. This is simply regarding the availability of home protection plans, and it is saying that the buyer and sellers acknowledge having been advised that these are available and that a home protection plan is either is to be provided or is not to be provided. We're simply checking the box. Now, if it is to be provided, we're going to state who's paying for it by checking the correct box and how much it would not exceed. Otherwise, they would pay up to X amount. You may want to be specific because otherwise, here's what you're going to get. You're going to get a base plan. Now, if that's good for the buyer, great. If I wanted something specific, it would have to go into the additional conditions at the end of the purchase agreement. Paragraph number 9 deals with the earnest money deposit. We're going to state in this blank who is going to hold it. Normally, that is going to be your office. So you're going to put in here either Coldwell Banker Professionals, if that is who your affiliation with, or Century 21 Professionals, if that is who your affiliation is with. Now, that is known as the escrowee. This could be a title company. Now, not common, but it happens, and if so, we would put that title partner in here. The amount of the earnest money deposit. Now, let me throw this out. I'll give you the GAMAP. Get as much as possible. See, we're trying to write an offer that's very acceptable, and the larger the earnest money deposit, the more good faith that the buyer is saying that we will complete this sale. I'm willing to lose this money if I don't complete this. Well, the larger, the better. Get as much as possible. Then one thing I would say, don't exceed the amount of your compensation. If it's 3%, get 3%. Now, might I get more and have I? Absolutely. You might get that, and then just remember this. About 1 week prior to the closing, you're going to have to ask for an overage. I'm going to encourage you to talk to your broker manager or your admin about what the overage means and how to be able to get that. But again, 1 week out, if you have collected more than what our compensation would be. Now, that can be in the form of a check, a money order, cashier's check, certified funds, and our company even has the opportunity to where it can be wired directly to us as the escrowee. Now, it then says the EMD will be collected and deposited within blank calendar days of acceptance by the seller. So, I'm going to say you're probably going to put anywhere from 0 to 5 days. 0 means I have it. Okay? Up to 5 days means that by the 5th day, we'll have it and we will deposit it. Okay? Now that is legal by the laws of the state of Michigan because we're living up to the terms of the purchase agreement. And then we will deposit it, we will, within 48 hours. Now let me highlight one other thing. As an agent, the state of Michigan also requires that when we receive someone else's money as an earnest money deposit, that you as the agent will turn that into the broker as soon as possible. Now, I believe it even says immediately. Now, that just means, look, if we're closed on a Friday and you get it Friday evening, well, we're not open on a Saturday, we're not open on a Sunday, but first thing Monday morning, you would bring it into the office. Now, the total sums deposited will be deemed the earnest money deposit. It will be held in accordance with the laws of the state of Michigan, applied toward the purchase price at closing. I even make sure that a buyer understands it will be applied toward the total amount that you need the day of closing. It will be applied to the total amount of cash you need the day of closing. The earnest money deposit shall be dispersed only in accordance with either the terms thereof or hereof, a fully executed mutual release, or until a civil action is determined to whom the deposit must be paid. If offer is made is not accepted by the sellers, the earnest money deposit shall be returned to the buyers. Let's move on to paragraph number 10, closing. Subject to the conditions herein, closing shall take place on or before, and guys, this is probably another great question of the mortgage partner. Whoever's handling this mortgage, the mortgage originator, is a great person to talk to regarding this. They know how long it will take them to be able to get the loan approved, and then we would need 3 to 7 days to be able to get this to close. So, seller shall deliver, subject to all conditions herein, closing shall take place on or before. And we're going to put that date in there. Typically, that's about 30 to 35 days. It may take longer depending upon the type of loan, such as an FHA, a VA, or if there might be a MSHDA tie to that. The closing will be at a mutually agreed upon location. Buyer shall not be deemed in default, and this is an important one I want you to remember. Buyer shall not be deemed in default of this agreement for any delay beyond the agreed upon closing date due to reasons associated with truth in lending and or federal disclosure requirements related to the buyer's good faith estimate, and the closing date shall be extended for the period necessary to satisfy these requirements. Guys, if you get into a sticky situation, one, remember that, but obviously talk with your managing broker regarding closing dates, because these are not a hard date, meaning they don't necessarily need to be met on that particular day. Let's move to paragraph 11, possession. Sellers shall deliver to the buyer check either at closing or by checking at 11:59 a.m. There's a reason, because people don't always understand what noon or midnight actually is. So we go to 11:59 a.m. so everybody knows that's in the morning, daylight time. Blank days after closing. Closing to apply if no choice is made. Make a choice. If possession is not delivered at closing, from and including day of closing through the date of vacating the property, so through the date, seller shall pay the blank amount, the sum of blank per day. Now, depending on the market at the time period of you making an offer, depends on how a buyer might decide to do this. They may decide to charge a fair market rent. So if it was a home that would collect $3,000 a month, well, that's $100 a day. Others might decide that it's 1/30 of the PITI. Others might give them time with no cost at all. I want to make sure that my offer is a great offer. I might charge $0. Either way, it's something that you need to take into consideration. Now, here's the rest of the paragraph. Designated escrow agent shall retain from the amount due the seller the sum of 1.5 times the daily fee times the total days for occupancy. So if we're using our $100 a day, that's 1.5 times. That's going to be $4,500 that would be held in escrow. The designated escrow agent shall disperse the occupancy fee due buyers every 30 days. Now, I'm going to let you know, 60 days, if there's financing involved, 60 days is the maximum amount of time that a mortgage company will allow a buyer to give possession at, because they want the buyer in this home within 60 days. Now, there's exceptions to that, but we're talking a buyer buying a home as their primary residence. Now, from there, seller shall be entitled to any unused portion of the occupancy as determined by the date property is vacated, and key surrendered to the buyer, the listing broker, the selling broker. Now, I'm going to tell you that I believe the best way is to surrender to the buyer. That leaves us the option as to whether or not we're going to be there at the time period with the surrender of the keys. If I put that it's surrendered to me, then now they're coming to me and now I've got to handle everything. I want you to do buyer and gather your managing broker's thoughts, but it's just the aspect of simplicity. Why are the other two options there? Because it's how it can be handled. Now, seller is legally obligated to deliver possession as specified herein. It's a legal binding agreement. That's when they have to do it. Now, this is a, what if they don't? What if they're not following this legally binding agreement? If the seller fails to deliver possession as specified herein, seller shall pay blank dollars per day. And maybe, know this, it's not just the dollar per day, but may be liable for the cost of eviction, actual attorney fees, any damages, and other costs incurred by the buyers in obtaining possession and collecting the amount due. Now, I think it's important. I'm going to come back to that, but brokers have no obligation, implied or otherwise, as to the condition of the premises to see that the premises are vacated on date specified. Now, I want to go back. How much do I put in this blank for the per day? Now, up here, we're probably doing fair market rent. But here, this is a penalty. Now, for some of you, I'm going to get a little crude here for a moment. But I look at this as a fee, and I call it, get the hell out of my house. Now, I'm apologize because that's kind of crude, but I hope I've landed the point. The buyer just purchased this property, and they want to move in as planned. This is a penalty fee, so we're going to make it hurt. If we've got $100 a day, look, this is double. This is $200. That's probably $300 or $400 a day. Depending upon the size of the house, that could be even more. Here's my point. Make it hurt. Get out of my house. That is what this second blank needs to say. Get out. It's my house. Get out. All right? Now, sewer and water charges. Sellers agreed to pay for all sewer and water charges to the date of closing or possession, and it's possession if no choice has been made. Now, guys, here's my recommendation. And I'm not saying it's the right one. Check with your managing broker to see what their opinions are. But my experience tells me that I like to do it to closing. And here's the reason. If I have 30-day possession, 30 days later or less, I've got to make sure that we get a final water reading, final sewer bill, water sewer bill. I've got to make sure that that's been done. If I don't, that's going to harm my buyer because it goes with the house. So until you got that final read, buyer's paying. Okay? So that's the reason I like the date of closing. That is something that I know, the date of closing, I have to get. I'm thinking about it. It's on my checklist to make sure that occurs. Up to you as to what you do, but look, 30 days is not going to make a whole lot of difference in regards to what the water bill may be. Let's see, the designated escrow agent shall retain from amount due sellers at closing blank dollars. Now, why did we leave that blank? I'm going to tell you that you want to put at least $300 in there, but there are municipalities where the water bills are much higher. If you are selling in one of those municipalities, you need to know that that could be $500, $600. Find out what it's going to be and what's best to be able to protect the buyer. Paragraph 13, title evidence and the survey. Seller agrees to order title insurance upon acceptance of the offer and to furnish buyers a commitment of title issue which is to be issued in the amount of the purchase price. So the seller is providing an owner's policy of title insurance to the buyer. After closing, an Eagle/Advantage type policy of title insurance at seller's sole cost will be issued in the amount of the purchase price bearing the date of closing or later guaranteeing title and condition required for performance of this agreement. Title commitment shall be marked up at closing, ensuring through date of recording. The real estate broker has recommended title insurance. Buyers secure and pay for a survey if required by the title company or desired by the buyer. Let me state that again. The buyers to secure and pay for a survey if it's required by the title company or desired by the buyer. Pretty much self-explanatory. Now, what if they receive the title commitment and there's issues? Well, it states this: if objection to title is made based upon written notice that title is not in marketable condition required for performance hereunder, sellers shall have 30 calendar days from the date notified in writing of particular defects claimed to either remedy the title or obtain title insurance satisfactory to the buyer. Those are the two options. Now, there's just things that happen on title. Hopefully, we ordered pre-title. We recognize what those issues were and that we've satisfied those. Now, that gives 30 days if for some reason it hasn't been for the seller to get those corrected. Otherwise, the buyer has the right to walk away. So buyer agrees to complete sale within 10 calendar days or written notification that the title has been remedied or by date specified on the purchase agreement if it's later. So if we get it fixed, we get it fixed and we close on time. If sellers or seller is unable or unwilling, because there's sometimes the inability, and sometimes they are unwilling to remedy to take what is taken care of within the specified time, buyers will waive requirement in writing within 10 days of written notification thereof, or the agreement may be declared null and void at the buyer's option. Last one on here is a simple notification that the buyer has agreed to pay all closing fees charged by the lender, the title company, along with a compliance transaction fee of $395 payable to Coldwell Banker Professionals, or that would be Century 21 Professionals at closing. Now, that's an agreement that they've already signed prior to. We know that that is just part of our overall compensation. So, guys, that brings an end to page 2. Take a brief break, and then let's come back together. We'll take a look at page 3. See you soon.